just wait till everyone gets out so we can devote our full attention to you.
Good afternoon, Your Honors. My name is Brandon Carnes, and I have the pleasure of representing the appellant, Ragan Construction Company, Inc., doing business as Southern Roofing of Tennessee, and the privilege of appearing before this court for the first time. So thank you for your time today.
First, you shouldn't have told us it was your first time, you know.
Well, hopefully you'll go easy on me, Your Honors. At this time, the appellant respectfully requests 3 minutes for rebuttal.
3 minutes, okay?
This case before the court today presents important and interesting questions concerning the burden of proof on an employer concerning a non-solicitation provision in an employment context, and ultimately the enforceability and limits of such provisions under Tennessee law. Today, we're asking the court to reverse the trial court's July 1st order granting summary judgment to the appellee for several reasons. Fundamentally, the trial court granted summary judgment in favor of the appellee despite a procedurally deficient motion that did not comply with Rule 7.021, or local rule equivalent 2601. There were also genuine disputes of material fact below. Somewhat uncommon for my practice, this case presented a circumstance where the facts were not incredibly disputed by the parties, but the inferences and conclusions drawn from those facts were wildly disputed. The credibility of the witnesses were challenged, and ultimately the trial court erred by accepting the appellee's version of events in whole and not drawing any inferences in favor of the appellant as it was required to do by law under the applicable standard. And fundamentally, the trial court also misapplied Tennessee contract law concerning an employer's interests in its clients and business lists, and also the materiality of what occurred below with respect to the appellee's breach. In considering the motion for summary judgment that was granted below, it's necessary to start with a consideration of the facts, and I'll just highlight the most salient of those very briefly. I know the court has read the briefs very thoroughly. The appellee, Mr. Koren, was an employee of Southern Roofing for over 11 years. Over the course of that relationship, the appellee entered into a non-solicitation provision with the appellant, which was exceptionally broad. Mr. Koren agreed not to solicit directly or indirectly, or to take away a customer of Southern's directly or indirectly for a period of 1 year following the conclusion of his employment. Ultimately, Mr. Koren was terminated on March 31st of 2023. That very day, within hours, he contacted the Diocese of Nashville, the Catholic Church, within hours, and through his contact, Mr. Paul Netter. Mr. Netter and Mr. Koren had worked together for many, many years and had a long-established relationship that was brought to Southern by Mr. Koren. But within that day, within hours, Mr. Koren did exactly what he pledged not to do when he contacted the diocese and discussed the separation of his employment.
Counsel, the contact occurs after the expiration of the offer, right? So, and the offer's made, it's open for 30 days, it expires. The trial court made a finding that I found interesting. Southern Roofing's proposal for the diocese work had expired, and included that in the discussion of the undisputed material facts. I'm trying to understand the consequence and significance of that determination. Is the trial court determining that the diocese was not actually a customer in this case? Is that the determination that's being made through that factual or through that understanding of the undisputed material facts?
Well, the trial court erred when it considered that, Your Honor. First, it's important to note that Southern put on undisputed proof below in its statement of additional material facts that it routinely considered proposals that had been expired and routinely offered those prices to customers. And this offer likely would have been accepted, and that was not disputed on summary judgment by the appellee. But to the court's point, the court conflated, I think it was attempting to reach the issue of materiality, what it was really considering was the issue of damages, which was there could not have been damages here because the diocese was not going to do business with Southern one way or the other. But that's not actually the issue in this case. What is at issue is the materiality of that breach. Mr. Koren did not contract for Southern to have an unending guarantee of future business with its existing customers. What it contracted for was for the appellee not to interfere in those relationships, which is exactly what occurred. And the materiality of that breach, that is exactly what Southern bargained for in the non-solicitation provision, regardless of whether or not there are damages. And I think there's an important analogy, I know judges love analogies, in the context of a construction contract where a general contractor requires a subcontractor to maintain certain liability insurance. The failure to obtain that insurance, of course, is a material breach, regardless of whether there was ultimately a claim or a loss. The general contractor has an absolute right not to do business with a subcontractor who fails to obtain the required insurance, just by way of example. Similarly here.
The non-solicitation provision mentions customers or clients. What's the distinction between the two?
I don't think there's a material distinction for purposes of this case below, Your Honor.
Well, I mean, in any case, why would they use two different words?
Perhaps a scrivener's error or drafting.
Just means the same thing?
Overzealous counsel. From my perspective as counsel, I do believe they mean functionally the same thing.
Okay, and so if they mean the same thing, what is the meaning then of a customer then for purposes of this agreement?
A customer is any client or...
Is it a defined term under the agreement?
I don't believe so, Your Honor. If it is, I would have to check the record again. I believe a customer is any party with an established business interest with Southern Roofing. And here, Southern Roofing...
So what was the established business interest here? Was it past work?
Yes, they'd worked with the
So
Southern Roofing.
anybody that Southern Roofing had worked with in the past falls within this non-solicitation provision?
For a period of 1 year, I would argue yes, Your Honor. I don't think there's any limitation within the non-solicitation agreement. There were no carve-outs for customers or clients brought by Mr. Koren or any other limitations. Any customer or client of Southern was not to be solicited or taken away by Mr. Koren for a period of 1 year. It's exactly what the agreement
And
says.
the solicitation here you're referring to is the telephone call that Mr. Koren made to Mr. Netter.
There's multiple solicitations.
And what are they beyond the telephone call?
Sure. There was essentially the trial court should have looked at this from a totality of the circumstances approach. There was the initial telephone call on March 31st of 2023. There was a subsequent telephone call on April 18th of 2023 when Mr. Netter said he wanted to proceed with the Sagrado Corazon project to the appellee. The appellee said, send me the bid from Southern so I can refamiliarize myself with the project and let you know when I can get to it. There was also an email to that effect. We also know from the facts below that ultimately Mr. Netter did in fact send the appellant's bid to Mr. Koren. Mr. Koren used another estimator at his new employer to send a functionally identical proposal at a lower price to the diocese and acquired that project. So that's exactly what occurred here. And over that period of 3 weeks, Mr. Koren successfully solicited the business of a Southern customer. So
it's those basically two exchanges, which are the first
Yes.
termination and then the exchanges on April 18th.
at least those two exchanges we're aware of, Your Honor. The course of conduct, text messages, multiple phone calls, and an email over the course of those approximately 3 weeks.
So with the follow-up exchange was a call from Mr. Netter initially, right?
Yes,
On
Your
behalf of the diocese?
Yes.
Okay. But you're attributing that as a solicitation by Mr. Koren.
Yes, Mr. Koren invited the...
Did he compel Mr. Netter somehow to call him?
I don't think he twisted his arm, Your Honor, but the fact of the matter is during the initial contact on March 31st, the parties functionally agreed, and the record asserts below that Mr. Netter would keep in touch, quote unquote. And
You indicate in your briefing that there are disputed material facts here, but I'm looking at the statement of undisputed material facts, and I really don't see them. I mean, most of the facts as stated are undisputed, with the exception of two, and it looks like there are objections, which, why wouldn't those be just deemed admitted? I mean, there's no place for an objection under Rule 5603, is there?
well, I think in the context of specific facts, it's at least routine practice if the rule does not specifically enumerate objections, whether or not a fact is properly included in a statement of facts. I agree that the underlying facts are largely undisputed in this case, and it may have been a misnomer to assert there's a dispute of genuine material fact. In reality, what's disputed are the inferences and conclusions from those facts. For example, the appellee asserts that his contact with Mr. Netter on March 31st was just to announce the change in his employment. Another inference that could be drawn is the immediate impact of not accepting Southern's bid, not contacting Southern, not working with Southern and holding off on proceeding with that project until until the appellee acquired new employment, which is exactly what occurred.
Is there any case law other than the Merrill Lynch case that you've cited that indicates a solicitation, that informing someone that they have been terminated constitutes a solicitation?
There's a paucity of cases on this topic under Tennessee law. Both parties, I think, acknowledge that this is not a well-settled issue under Tennessee law. Both parties cited extensive cases from other jurisdictions, often in other contexts.
What strikes me is the Merrill Lynch case seems clearly distinguishable here because the employee in Merrill Lynch, wasn't he already hired or went on to Dean Witter, so he had someplace to go, or he had someplace to take the business.
Yes.
With the announcement. Here, that's not the case, right?
Correct.
You couldn't have a situation where Mr. Koren could have said, I've been terminated. Oh, and by the way, go ahead and submit a bid for roofing. He had no way to do roofing work.
Well, and that was the purpose of saying that they would keep in touch. He didn't have an employer yet, but he agreed to keep
Didn't Mr. Netter, though, say we'll keep in touch?
He did, but that was certainly the purpose of the call. This wasn't an invitation to Sunday church or a Friday poker game. This was not a casual, personal relationship. The purpose of the call, at least one reasonable inference from that call, was to maintain the business relationship between Mr. Netter and Mr. Koren.
Counsel, does it matter here that there was a relatively recent proposal that had been made by the appellee in this case, where he had been in charge of submitting a proposal to the diocese, right, in terms of approximately 31 days before he's terminated. So this conversation is also in the context of him having recently submitted a proposal to do work for the diocese.
Right. The temporal proximity of that, I think, is an interesting issue, Your Honor. The appellee knew that Mr. Netter was actively looking for someone to complete this work, and that is why he immediately contacted Mr. Netter. Perhaps he would have waited a longer period of time if there weren't a pending quote, or if he hadn't known that that work was necessary to be completed. In fact, the appellee testified below that he had no recollection whatsoever that he was bound by any non-solicitation provision when he made that March 31st call and asked Mr. Netter to keep in touch. So it's clear that at least one impact of that call was to put Mr. Netter on notice not to work with Southern, to hold off, continue to work with me as you have for nearly 20 years, and when I land at my employer, wherever I do, you can contact me and we'll take on this job. That's exactly what happened, even utilizing the appellant's confidential information, including its bid on the project, Your Honors. I see my...
Wait, you said use your client's confidential information. What was the confidential information?
The pricing information was confidential, Your Honor, as well as, I don't think that was a matter of public record.
So when bids are submitted to potential customers, they're informed that they can't share the bids with any other party?
Well, I don't think that extends to a customer necessarily. Their customer's not bound.
So it's confidential except for customers that receive the bid?
I think Southern expected its employees not to share its methodology for estimating and bidding projects.
But I don't understand how that would work. Normally, pricing is not a confidential matter. Sealed bids, yes, but if you're out in the marketplace, don't you expect your customers to shop around for other roofing companies?
Of course. Ultimately, confidentiality may not be material to the resolution of this case, but the point is the appellee used insider information he'd gained from his employment with the appellant.
Okay, wait. No, well, I want to make sure. So confidential, now you're saying it's insider information, but this is information of pricing that's given to customers and they can do whatever they want to with it.
He could have, yes.
So it's really outside information.
Yes, and it is not necessarily germane to the resolution of this appeal, Your Honor. Thank you.
The information that this particular diocese had solicited a bid from Southern.
I'm sorry, Your Honor?
It was confidential or company information that they had submitted a bid to the diocese.
It absolutely was, Your Honor, yes.
Okay.
And that is something the appellee abused when he sought the diocese business. So, thank you.
Good afternoon, David Johnson for the appellee. I first want to address the last point of discussion, which is about confidential information, because that was an issue, an argument that they had initially suggested that Mr. Koren breached by disclosing confidential information. But then when we got to the ultimate summary judgment filings, they abandoned that argument. So there has not been any argument by Southern during this appeals process that Mr. Koren breached the contract by divulging confidential information, nor was that argument presented to the trial court at the summary judgment hearing. So I want to first clarify that. But at the heart of this case is a declaration from Paul Netter with the Diocese of Nashville. And it's undisputed that the diocese was a longstanding client of Mr. Koren, and that it had followed him to multiple jobs before, even before he joined Southern Roofing. And that declaration is important for two particular points. One, that Mr. Netter testified that Mr. Koren never asked for business. He was never solicited. Instead, it was Mr. Netter was the one reaching out to Mr. Koren. And then second, equally important, that once Mr. Koren left Southern Roofing, the diocese was no longer interested in doing business with Southern Roofing. The only reason why the diocese was doing business with Southern Roofing in the first place was because Mr. Koren was there.
Counsel, under your understanding of non-competes, do you have to prove that not only did the person compete against you, but that you actually lost business as a result of that for a violation of the non-compete to have occurred? Are we tacking that on with your understanding as an element of every single non-compete in the state of Tennessee, that now I have to prove not only that they competed with me, but that I actually lost business as a result?
The answer, Your Honor, is no. But I want to make sure there's a distinction here. I interpret Your Honor's question as suggesting in a typical non-compete case, whether that's the case, and I would absolutely say the answer is no. But here, this is a different context. This is a context in which someone is using the first material breach as a defense to excuse performance. And so in that context, the context we have here, where somebody is contractually obligated to pay $41,000, a bonus that was due, and they use as the only excuse for not paying that bonus that the adverse party is in breach by violating it.
Why is there a difference between, aren't we talking about a breach in both of those circumstances? Saying I use it as a defense, I bring an action for breach. Doesn't this go to the extent of the damages in the case rather than whether an actual breach occurred?
Well, it could, except that in most typical non-compete cases, and I do a lot of them, in a significant number of them, the primary relief that the plaintiff is seeking is the injunctive relief. And so they're focused on the threatened breach, and a court precluding the defendant from breaching the contract. So in that context, if there's a reason to think that the defendant is going to breach, then that is a basis to award injunctive relief. But if performance is going to be excused, that's different. We're talking about the first material breach, something that occurred in the past. And so in that instance, there must have been a breach that must be proved in the past if that party is going to be excused from performance. So that's how I would answer that. But through this date, Southern has not been able to articulate that it lost a dime of business as a consequence of the diocese, because Mr. Netter made very clear in his declaration that the diocese was not going to continue to do business with Southern because
Does that argument work for the taking away component of it? So the non-solicitation provision bars both solicitation and also to take away a customer or client. Assuming for the sake of argument here that the Diocese of Nashville is a customer or client, how were they not taken away?
So yes, a couple ways to answer that, Your Honor. And first of all, the taking away was not an argument that was raised until the reply brief and before this court. It was all the solicit, okay? But in terms of the taking away, I believe this actually ties in to Judge Usman's area questioning earlier. Because to take away, a classic example of taking away would have been that job Your Honor referenced, that a bid was submitted on behalf of Southern for that job that expired. And if that bid had been accepted by the diocese, and then Mr. Netter left, and then Mr. Netter convinced the diocese to take away that job, he goes to the diocese and take that job, pull that job away from Southern and instead give it to his new employer, My Roofing Crew. That would be a classic example of taking away. And I think there are two fundamental principles of contract interpretation that really are pivotal here. One of which is that any ambiguities are construed against the drafter, which was Southern. And then second, because this was a contractual provision that is a restraint on trade, a non-solicitation provision, then again, any ambiguities are construed in favor of free enterprise and competition. So if these are undefined terms, solicit is undefined, take away is undefined in a contract that Southern wrote, and to the extent that there are any ambiguities there, they are to be construed against the drafter.
Judge McBrayer, in asking this question, mentioned the concept of customer. I want to ask you the same question I asked opposing counsel. There's some language I find intriguing in the trial court's decision where it says Southern's roofing's proposal for the diocese work had expired, and it also references earlier in the factual recitation that had been more than 30 days. Does that go to the customer issue? And is the trial court telling us that they're not a customer, or are you essentially conceding that they were a customer of Southern?
Yes, sir. I do not think that's what the trial court was getting at there. I would concede that they were a customer. Okay. What I believe the issue to be was that, or the point that the trial court was making, and I would be speculating here candidly, but I think she was saying that this job was not taken away. It was not taken away under that clause because it had expired. There was never an acceptance of that job. That's what I believe. But I did want to bring up an alternative point that we made when we talk about that job and this client, that even though Tennessee courts have not addressed this, that there was no protectable business interest to warrant Mr. Koren being restricted from the diocese, because the diocese was a long-standing client that he had introduced to his employer, Southern. And when Tennessee courts have looked at the determination of a protectable business interest in the context of these non-compete, non-solicitation restrictions, courts have found that yes, an employer has a protectable interest in protecting its customer relationships. But other courts that have addressed this issue, and these cases are cited in our appellee brief, have found that there is much less, if at all, a protectable business interest in a situation in which the client is introduced to the employer by the employee, as opposed to the other way around. It would be one thing if Mr. Koren learned the diocese, developed a relationship with the diocese by virtue of his employment with Southern, such that Southern has a protectable business interest in restraining that relationship. But here, this was a situation, unlike a typical deal, where the diocese had followed him to multiple jobs and had been a long-standing, as Mr. Carnes acknowledged, has been a long-standing client for many years.
Going back to the takeaway issue, let's suppose, in going to the finding by the court that the bid had expired, let's say that the bid from My Roofing can't remember the name of my roofing company, whatever, hit Mr. Koren's new employer, had come in within that 30 days, would that and then the diocese took that bid, would that be takeaway?
I don't, and I think I understand your question, Your Honor. I don't think so, because,
Southern Roofing would have had to actually start work, or?
well, I think the diocese would have had to have already accepted the bid for it to have been taken away from them. That's how I would look at it, Your Honor. Let's see. I think the question was brought up during Mr. Carnes's presentation about he referred to the paucity of Tennessee law about some of these issues about what constitutes a solicitation. And I would suggest that, yes, there is a paucity of Tennessee case law. The only Tennessee case law that we could locate that really addressed the issue just looked at how does an ordinary dictionary define the word solicit.
Counsel, how does the word indirectly impact that? So in looking at the non-solicitation provision, employee agrees not to solicit or take away or attempt to solicit or take away directly or indirectly. How does indirectly impact our understanding of solicitation?
Yes.
As a starting point, I would think of solicitation as a direct action that no one engages in, but this clearly goes beyond that. So,
well, as that counsel my clients, Your Honor, who deal with these issues, I tell them a classic example of an indirect solicitation is asking your coworker to do what you're not allowed to do, asking somebody else to do. So in other words, if Mr. Koren had gone to his new employer, my roofing crew, and said, listen, I can't solicit the diocese, but you can. And here's Mr. Netter's contact information. There's an opportunity here. So why don't you solicit them? That is an indirect solicitation. That would be a classic example.
isn't that what opposing counsel's saying has happened here, though? And your client indicated, I'm no longer with Southern. And just to let you know, I'm out the door. There's a long-standing relationship here. There's a recent bid that's been made relatively quickly, is with a new roofing company, which is what his professional background has been. And then he gets contacted by the diocese, and he turns it over to somebody at his new employer, who then makes the contact.
Well, there's a key distinction there, Your Honor, which is that the undisputed testimony shows that Mr. Netter is the one who affirmatively reached out to Mr. Koren unsolicited and said, I want you to do this job. And in fact, the undisputed testimony is not even that, hey, we want my roofing crew to bid on this job. What he said, and it's in the record, it's undisputed, what he said is, Mr. Koren, I want you to do the job. We're ready to go forward. For whatever reason, they were not ready to go forward at that particular point in time initially.
Does it matter that he's aware of the bid? And if I'm remembering correctly, the appellee requests information on the bid that was submitted. So he's aware of the bid that's submitted and to ask for that information. Is that of any consequence in this case?
No, the only reason he asked for the information was he forgot about what the project was about, and so he needed the information. He asked for the information so they didn't have to reinvent the wheel and it was an easy out to bid on the job, and that's in his deposition testimony, Your Honor. So for these reasons, Your Honor, we ask that you follow the approaches taken by courts in other states that have directly addressed situations like this, including in the context of summary judgment. Those are cited in our brief, and affirm the trial court's ruling. Thank you.
Thank you very much. Mr. Carnes?
That's all right. I'll be very brief on rebuttal, Your Honors. This was a very close case, as the trial judge acknowledged below. She acknowledged as much during oral argument, and she also reflected that when she denied the appellee's request for prejudgment interest in her subsequent order. We heard a couple of points from Mr. Johnson I just want to clarify very briefly. He opened by suggesting that the diocese was not a customer of Southern, but was rather a customer of Mr. Koren. And I know we raise it in our brief, but to be clear, that could not have legally occurred here because of the Tennessee Contractors Licensing Act. Mr. Koren was not legally capable of servicing that relationship. He had no contractor's license. It was an existing customer of Southern, and this isn't the case of an employee bringing a longstanding client and being terminated after a year. Southern had worked with the diocese for 11 years since Mr. Netter came into this employment.
So since Mr. Koren came.
Yes, excuse me. Second, there was a question from the bench concerning the impact of the term indirectly. And I think we heard from Mr. Johnson that his interpretation of indirect solicitation is practically what occurred here. Rather than turning away Mr. Netter or indicating he could not work with him, he requested a bid and told his estimator, a coworker, to get in touch with Mr. Netter to get that work and send a proposal.
But, I mean, the bottom line is it's your client's position that to comply with the non-solicitation agreement here, Mr. Koren was under affirmative obligation that when Mr. Netter called and asked for a quote, Mr. Koren had to say, I can't provide you a quote.
Absolutely, Your Honor. That's absolutely what he agreed to. The language in the non-solicitation agreement, which is not a non-compete, by the way, it's narrower. That's an important point as well. It's narrower. Was unambiguous and very, very explicit, and that's exactly what the appellee violated here.
And then if we send this back, really we're sending it back for a trial for the trial judge to hear basically Mr. Netter and Mr. Koren testify.
Yes, yes, Your Honor. There are questions of fact on the credibility of the witnesses. There's questions of fact about the materiality of the breach. We heard from Mr. Johnson during his oral argument about Southern not losing a dime, but again, that goes to damages and not the materiality of the breach.
And so at summary judgment, how did your client put either witness's credibility at issue?
Well, we questioned the inferences from their testimony. There were objections to portions of their testimony. The underlying facts, while largely undisputed, did have inferences that were disputed as to the timing of those communications and what ultimately resulted in a new business relationship between the diocese and Mr. Koren's new employer. So in conclusion, Your Honors, there was a clear violation of Rule 7.02 to the extent the appellee failed to clearly identify the grounds of his
Question on
motion.
702, is there any prejudice in this case, counsel?
I think there is, Your Honor. While there was a thorough memorandum of law and a thorough statement of facts, ultimately, rules are rules, and the law is the law, and it should have been applied in a very specific way. And the appellant was entitled to notice, very specific notice that should have been outlined in a motion that would have guided the appellant's discovery and the response instead of searching sort of through a needle in a haystack. Legal arguments are very broad. The renewed motion for summary judgment was quite lengthy. There were a number of factual issues. There were a number of legal issues. And if those had been clearly articulated in a motion, which is required to invoke the jurisdiction of the trial court, this case may have proceeded differently below. We respectfully ask the court to reverse the July 1st order and remand this for the completion of proceedings and trial. Thank you.
Thanks to both of you. Would you call the next case, please?
City of Hendersonville versus J&J Ventures LLC.